I'm Mark Warda, author of Land Trusts in Florida, and I'm going to tell you about Florida's new land trust law, which the legislature passed in 2013. This new law follows the laws from 2006 and 2007, which made the land trust law better and more useful for those of us who use land trusts to invest in real estate. I'm on the committee that wrote the land trust law, so I was able to give them some input on things that we need in the law, which will make it much better for investing in real estate. The first thing the new law did was take the powers of the trustee and put them into a new statute. The reason for that is that there was a long drawn-out lawsuit that went to the appeals court and the Florida Supreme Court among a family of attorneys who were suing each other over a living trust. And the issue was that the trust used a deed with the land trust powers, and the statute says if you use that, you're no longer a living trust. So that caused a major problem for all the living trust lawyers because they all use these deeds, and they might be charged with malpractice because now their trusts no longer were under the living trust law. So they wanted this new law taking the powers out and putting them into a new statute, which is what was done. Now there's a new statute, 689.073, listing the powers of a trustee, which can be used for both our land trusts and their living trusts. The next thing it did was list what is a land trust so we don't get mixed up with living trust. And it says that in a land trust, the trustee can only have limited duties. There are 4 duties the statute now says a trustee can have in a land trust, and those are to follow the beneficiary's direction, or to close the trust and deed the property to the trustee at the end of the trust after maybe 20 or 30 years, or to just do ministerial or administrative things, or if it's a timeshare, the trustee can do whatever duties are included in the timeshare statute. The next thing the new statute did was to say that the statute of uses doesn't apply to land trusts. The statute of uses, believe it or not, is a statute from the year 1535 when King Henry VIII said that if a trust doesn't have any duties for the trustee, it's void. And believe it or not, also, title companies, even now, say that if your trustee has no duties, then we need a deed from the beneficiary, based on that old statute. So what our new change to the land trust statute says is that the statute of uses no longer applies to land trusts. So even if the trustee has no duties, we don't need a deed from the beneficiary, so we don't have to put his name out on the public records. The next thing the new statute does, it says that merger doesn't apply to land trusts. The whole idea of a land trust is that the trustee has legal and equitable title to the property. And merger is an old doctrine that says if ever a trustee or beneficiary gets legal and equitable title, the trust is void. And that was used by a Miami bankruptcy court for someone to lose their property because they said there was merger. But that makes no sense because in a land trust, there can't be merger because the trustee already has legal and equitable title. So now the new statute says that a land trust can't be closed because of merger. The merger doesn't apply to a land trust. The next thing the new statute does, it already in 2006 said that the beneficiary is not liable for the property in the land trust. So that's a great thing. Your land trust now gives you liability protection just like an LLC or a corporation. But the new statute says that those liabilities of the beneficiary can be expanded or contracted by the trust agreement. So of course we would contract the beneficiary's liabilities rather than expand them. The next thing that the new statute did is it says that the beneficiary's interest can be mortgaged like real estate. Now the statute says the beneficiary's interest can be personal property. So I'm not sure why there was an attorney who wanted it to also be treated as real property to file a mortgage. Maybe he filed a mortgage and needs to cover that mistake. But in any case, the statute now says that a beneficiary can file a mortgage against his beneficial interest, but it won't affect the real estate. So that's something that I don't think I'll ever need to use in our land trust practice, but it's there for someone who might need it. The other thing that the new statute does, it says that there's no guardian needed if there's a foreclosure against a land trust. What's happened is we have some foreclosures against land trusts. They serve the trustee who has legal and equitable title, but then they also want to appoint a guardian for the interests of the beneficiaries, to protect those beneficiaries. Well, the beneficiaries don't have legal or equitable title to protect. And sometimes these guardians are just appointed because the judge or the attorney has a friend who doesn't have much business, so let's appoint him guardian and give him $500 to file some papers. So what we did was we put in the statute that when you're doing a foreclosure against a land trust, you don't have to pay a guardian to file papers for the beneficiaries. And what that'll do is, if you're trying to save a property in foreclosure, you won't have extra fees because of this guardian that they don't need to appoint anymore. The other thing that the new statute does is something that I specifically put in, is that when they send a legal notice to a land trust trustee, they need to tell him which property it's about. We've gotten some notices that say that, like from the Army Corps of Engineers, a postcard says there might be munitions buried on your property. Well, they didn't say what property or even what county. Or another letter said that a nuclear power plant may be built near your property, and they didn't tell us which property. And that doesn't do any good, since we have hundreds of properties. We don't know which beneficiary this should go to. So now the new law says that if you send a legal notice to a trustee, you need to tell him which property you're giving a notice about. All of these changes, plus a whole day of information about land trusts and other creative uses of real estate, will be in our new land trust seminar we'll be giving this fall through Land Trust Service Corporation, my company. For more information, you can see our website, floridalandtrust.com, or email me, mark@warda.net. That's WARDA. Thanks for watching.